Hi everyone, my name is Tom Kunkel and I'm making this video for the Silicon Valley Business School. Today I'll be doing a bit of a walkthrough on how a complaint for direct infringement of a patent is drafted for the Western District of Texas. So the first section we'll see here is in the boxes here, we're pretty much just going to identify the name of the plaintiff, name of the defendant, and the case number. We're also going to demand a trial by jury. That will cover at the very end of this video, though. In the first section, we're really just identifying the cause of action. We'll identify again the plaintiff and the defendant, and we're alleging patent infringement. So the next section will cover the parties here, and you can see the notes here on the side. We're going to identify for both the plaintiff and defendant what type of legal entity they are, their state of incorporation or whatever law governs that entity, and then the principal place of business. So for the plaintiff, let's say, for identifying the legal entity, it could be a partnership, it could be a limited liability company, it could be a corporation. We'll identify that here. Then we'll, write down that it's incorporated in this state or that state, and then we'll identify the actual location, the address of the principal place of business. For the defendant, let's say it's a corporation, we'll identify that there, and then we'll say where that corporation is incorporated. We'll provide the headquarters of the corporation, which is essentially the principal place of business. Now, some firms will include additional information here on how the defendant has contact with the with the forum district. Now that's very similar or oftentimes the same as what's covered in the jurisdiction venue section. So I'm actually just going to cover that next in the next section. For jurisdiction and venue, let's have a bit of a civil procedure refresher. We need three things here. We're going to need subject matter jurisdiction, personal jurisdiction, and proper venue. Subject matter jurisdiction is very easy. All patent claims are handled only in federal court. So the federal court, because this is a patent case, has subject matter jurisdiction. Next, we're going to say that there's infringement in the district, and we're gonna identify how this district has personal jurisdiction over the defendant. We essentially do that by saying that the defendant has, you can see it here, continuous and systematic business contact with the state of Texas. We want to mirror the language of the statute, distributing, using, offering for sale, advertising in the state of Texas. There's another theory we can raise here too, is that the defendant has, and we'll see here, purposefully and voluntarily placed the infringing product and services into the district, essentially via a stream of commerce. Now, we can raise both of those there for personal jurisdiction. And then for proper venue, we need to identify that that the Western District of Texas has proper venue over or is a proper venue for this lawsuit. So we need to identify that essentially the defendant has enough contact with the Western District of Texas to be subject to personal jurisdiction here to get proper venue. We'll pretty much use the same language as personal jurisdiction. That's identifying extensive contact or identifying, voluntary use of a stream of commerce to, with the intention of that customers in the district purchase or use the infringing product. So the next thing we'll move on to, next section really, we'll cover the patents in suit. So here, these aren't real patents. There's a 1, 2, 3, 4, 5, 6, 7, 8 patent and a 9, 9, 9, 9, 9, 9, 9, 9 patent. Let's say, both of these made up patents are going to be, the patents in suit. We're claiming infringement of both of these patents. So we're gonna say how the plaintiff has ownership of the patent. Maybe they're the inventor, maybe it's by assignment. We'll identify the patent and we'll attach to this complaint a copy of that patent in full. So we'll do that for both of the patents in suit. Now, what we'll also do here is we'll list patents and applications that are, owned by the plaintiff, but are not the patent in suit. So they don't need to be attached, but they are mentioned. So again, these aren't real patents. This is the 111 patent, the 222 patent, and the 000 application. And links can be provided as well for the court on those. But really here we're just showing that the plaintiff has other IP. So the next thing we'll do, this is very important. We need to identify what the accused product is. The accused product is what we're claiming the defendant has infringed our patents with. So count one, referring back to the 1, 2, 3, 4, 5, 6, 7, 8 patent, right, that we introduced earlier. The first thing we'll do is we incorporate all the prior paragraphs. So all the paragraphs up to count one. We incorporate those. Then this next part is really about notice. We need to, for damages later, this is very important. We need to identify that the defendant was put on notice of their infringement, at least as early as the time of service of complaint. Now, again, we're going to use the language of the statute here by using, importing, and or otherwise offering for sale the accused product. They continue to infringe, essentially. Now, here's a section where we will provide additional information. This paragraph might be several paragraphs. The information that can be included here often deals with the prosecution of the patent. So that's the office actions and the back and forth between the patent examiner and the patent agent. The patent agent and the examiner might have back and forth about 101 issues. That's patentable subject matter. It might deal with obviousness. It might deal with novelty. All of that may be addressed in this section. And this is to kind of preempt arguments later. But this section can be quite lengthy. So after all the information on the patent's been provided, we actually get into the meat and bones of the complaint. So we're going to give the claim that's been infringed, that we're claiming infringement of. So it might be claim 1, claim 19. So it's going to be some independent claim. And we're going to give that full claim language. All right. So that includes the preamble, the transition, then all the elements, right? So here I've just given an example that it's hard to do without an example. When this section is being done, you have two documents. There's going to be this document, the complaint, and another document, the evidence of use. It's a claim chart. And the evidence of use is going to have probably a lot of pictures of documents or screenshots of websites or pictures of the product, and there may be a lot of redlining and a lot of circling and emphasis added to it. So how do we incorporate that into the complaint is really a question here. So we would start off, let's say this is our claim 1 of whatever made up patent is being infringed. Let's say it's a method claim for a ride sharing app. So it's a mobile device implemented method comprising, so this here is the preamble, this is the transition comprising, and then these are the 3 elements: receiving a ride request from a user, sending the ride request to the closest driver with directions, collecting payment for the ride. So we look at our evidence of use, and we'd see we'd essentially pull over a screenshot after we write this here. So with the accused product, defendant performs here is the preamble, a mobile device implemented method. For example, according to the defendant's website, app, whatever, we are going to then input screenshots from the evidence of use. Now, the evidence of use is going to have, links to where that information is from. We're going to use footnotes here for that, to cite back to where that information comes from. Any sort of redlining or anything like that, we need to say emphasis added after the screenshot. So let's say we cover the preamble. So this is just really quickly, this is kind of atypical that a preamble would have information in it, but it's not necessarily uncommon. More often than not, the evidence of use might not even have the preamble. It'll just start with the first element. So again, we'll move on to the first element now. So with the accused product, defendant performs a mobile device implemented method, and then we're going to input the first element, receiving a ride request from the user. We're going to input here the screenshots from the evidence of use, say emphasis added, and add footnotes. We're going to do the same for the second element. We're going to do the same for the third element. Okay, that was kind of a lot. But once all of that's in there, this will take pages and pages and pages. You're essentially going to take all the information from the evidence of use claim chart, and you're going to bring it over and put it into the complaint in the correct format. So after all that's done, this is a very important paragraph. The plaintiff has been damaged by the defendant's infringement of the XYZ patent. Yeah. Then we'll go into count 2, the 999 patent. We'll do exactly the same thing. We incorporate all of the paragraphs before the first count of infringement, and then we kind of walk through notice. We provide additional information, and then we provide the claim in full, and then the entire evidence of use, and then we say that there have been damages. We end the complaint with two things. There's a prayer for relief, and the prayer for relief, the main thing here is to get the maximum recovery you can get. You want to ask for everything that you can get. So we'll start with that, yes, there's infringement. The plaintiff has suffered damages, and so we should be awarded for those damages. Attorney's fees are not terribly common, to be recovered by the plaintiff, but we want to ask for them anyways. So we're going to ask for attorney's fees, and we're going to ask for whatever else the court may find appropriate. Now, this relief is probably going to be injunctive relief. Injunctive relief can, it's a lot of case law on that. And then the last thing we're going to do is it's a demand for a trial by jury. This is, I guess, more strategy than anything. But that's the last thing we'll include. And again, going back to the very top, if we do have a demand for a jury trial, we need to say that a jury trial has been demanded. Alrighty. Again, I've been Tom Kunkel, and this video has been made for the Silicon Valley Business School. Thanks so much.